yes, we do have problems between two countries. We still not come to agreement, and I'm sure the Deputy Minister will be speaking about that. But from the expert point of view, we would like indeed to have a broader discussion. Doesn't mean that, you know, we're kind of trying to replace the official track. Official track will follow its own way. But I believe Azerbaijan extended hand to Armenia despite 30 years of occupation and destruction. It's Azerbaijan, I would like to underline, who proposed peace agreement, because sometimes, especially in some media outlets, we kind of see we're trying to portray Azerbaijan as a belligerent side, completely erasing the memory of what happened before 2020. So history of this problem has not started in 2020, it started before, as you know. And even if we look at the historical perspective, it is quite indeed almost 100 years history of the conflict. But again, the expert community is always, I believe, useful, bringing some new ideas. And that's why we decided to approach this conference from a bit different. So we even decided to invite Armenian speaker. So there's something new. Never been Azerbaijani speaker invited to any event in Armenia or even online. I know that the other universities have done some of the speaking engagement with Armenian speakers. So for now, we're going to have someone who will join through Zoom. But it's also, I think, important that we will have dialogue. So that's kind of short introduction. And now we will have the keynote speaker, Elnur Mammadov. And as you know, he's not only practitioner who takes part as a, you know, one of the team of the Minister of Foreign Affairs, but Elnur Mammadov also is focused on legal issues. As you know, we have some litigations. Azerbaijan put forward some litigation, and Elnur Mammadov, as a he has legal background, quite distinguished legal background. He is really tuned to that matter. So we'd ask Mr. Mammadov to speak not only maybe the obstacles between the peace agreement between Armenia and Azerbaijan, but also some legal matters. Elnur Mammadov, buyuruz. Söz sizin.
Sabahınız hayır olsun. Thank you very much, Ambassador, distinguished guests, ambassadors, ladies and gentlemen. So thank you, first of all, for the invitation. Very glad to be part of this conference today. And in fact, it is titled The Main Obstacle to the Peace Between Azerbaijan and Armenia. And as an informed audience, I'm sure you are well aware of the history of the conflict, of what two nations have gone through. The 30 years of occupation of sovereign lands of Azerbaijan, more than 1 million refugees and internally displaced persons in the early years of 1990s, after the collapse of the Soviet Union. And we have gone through a lot in order to be at this point today. And I would like to focus on where we stand now, but with a brief recap of how we've got here. So first, following the liberation of our lands in 2020 and then in 2023, we were, in January 2021, we were the first party to offer peace and normalization to Armenia. And you don't always see that the country that has prevailed in a war, has liberated its own internationally recognized sovereign lands, is the first to move, and offer peace to the other side. But we thought that was a right move, and we still stand by that decision. So for some time, we had no reciprocity from the other side. We have taken another step in February 2021, but said, okay, it's not just a peace agreement, but we want to formulate specific basic principles, which would be sort of the bedrock of any peace agreement. And we formulated those, I'm sure you're very well aware, the mutual recognition of sovereignty, territorial integrity, non-use of force, delimitation of borders, opening of communications, establishment of diplomatic relations. And then it took, so it's not a blame game, but it, as a matter of fact, it took Armenia more than a year in order to reciprocate even that offer and the basic principles. So between 21, 22, we were seeing this back and forth and not clear standing on whether Armenia wishes to have a peace agreement with Azerbaijan. And only in October 2022, we traveled with my minister as part of the negotiating team to Geneva in Switzerland. And that was the first meeting where we sat across the table, seeing each other first time eye to eye after 30 years. And that was the first sort of the kickstart of the process where we started going into the details of what that agreement would look like. And then ever since we had meetings here and there in the US, in Russia, in Kazakhstan, in Turkey, in other places. And as of now, we have the 11th iteration of the peace agreement. And we are very close to that finish line with a few remaining gaps in the agreement, which I won't be able to share today with you for the reason that they're still kept confidential. So we're not going into the details of what those specific articles are. So let me then focus on what we believe to be the main obstacle now, which needs to be lifted on our way to sustainable peace in this region. So very early in the process, we have identified not just one elephant in the room, but two elephants in the room, so to speak. So the first one was Armenia's constitutional framework. Specifically, I will concentrate on Declaration of Independence of August 1990 and the Constitution of 1995. And the risk that we see, which is not a hypothetical risk, because it is exactly the line of argumentation that the opposition of Armenia in the parliament of Armenia currently uses to attack the current government of Armenia, is that what you're doing contravenes our constitution. What you're doing contravenes the Declaration of Independence of Armenia, which poses a risk of this document being nullified or being considered null and void from the very moment of it being signed, or in the future by any future government. So it's not a hypothetical risk. This is exactly what the revanchist opposition groups in Armenia are advancing as arguments against the government of Pashinyan. And the second elephant in the room, so to speak, was the fact that while we were sitting across the table with the same colleagues from Armenia, the same colleagues, some of the representatives of this very delegation, they are defending a completely different position in international courts and in legal proceedings brought by Armenia against Azerbaijan. So at some point, it was quite ironic that you are seeing the same face, the same guy sitting across the table, talking about the Almaty Declaration, saying that it is the basis for the interstate delimitation of the borders and interstate borders between the two states. And the same person appearing before the International Court of Justice, appearing before the European Court of Human Rights, and saying the Almaty Declaration cannot define any borders. So it was turning a bit preposterous at some points. So let me quickly, given that we'll have a distinguished panel today that I'm sure will delve into more details, but quickly speak about these 2 points. So first, on the Declaration of Independence, it includes a constitutional objective to unify Karabakh with Armenia, based on a very well-known decision of 1989, the joint decision of the Armenian SR Supreme Soviet and Nagorno-Karabakh Autonomous Oblast to declare the unification. That was on December 1st, 1989. And the Declaration of Independence clearly refers to that decision, by the way, which was annulled then by the Presidium of the Supreme Council on January 10th, 1990, because it contravened Article 78 of the USSR Constitution at the time. So this has a reference to that notorious document, and the Constitution of Armenia itself, in its recitals, refers to the Declaration of Independence And by doing so, Armenia obviously gave this legal and political legacy that persisted even after that decision that persisted after the collapse of the Soviet Union. And interestingly, if you look at the constitution of Armenia, it refers in that specific part to the fundamental principles of Armenian statehood and nationwide objectives enshrined in the Declaration of Independence. So in other words, what they're saying is, what the constitution says is, the Declaration of Independence is a basis for the Armenian statehood, and it enshrines nationwide objectives. It sets out the nationwide objectives of the people of Armenia, of the statehood of Armenia. So this is not just another document in the legal domain of Armenia. So this has become a national ideology. Karabakh is part of Armenia. Although for many years it was not clear whether Armenia believes Karabakh is part of Armenia, or it's an independent state, or what it is. What is it in essence? Now, on a second point, positions before the international courts, I would have sort of two subpoints here. First, in the national courts, and specifically I'm talking about the ECHR and the ICJ, and second, the position taken by the government of Armenia in international organizations such as the UN, OEC, and other organizations, where the government of Armenia has kept distributing documents on behalf of so-called NKR. And that was happening in 2021. That was happening in 2022. That was still happening in 2023, until September 2023. And now, after September 2023, we have new documents by the so-called refugees from the Nagorno-Karabakh Republic. And that is obviously still posing a lot of issues as to the consistency of the position of Armenia. So more specifically, there's a principle called uti possidetis juris. I'm sure the lawyers know. Now, in layman's terms, that would translate into keeping these internal borders, the transformation of internal administrative boundaries of the Soviet Union into interstate borders. And interestingly, for 30 years, Armenia's position was that the Almaty Declaration did not define the interstate borders. It cannot define it. It has nothing to do with uti possidetis juris. That was the official position advanced in international courts. Now, one could understand that probably before the Second Karabakh War, before 2020. But interestingly enough, that was still the case after the Second Karabakh War. And we've been raising this consistently during those negotiations, saying you cannot have two contradictory positions here at the negotiating table and there at the ECHR or the ICJ. You have to take a clear position. What is it? Do we have the interstate borders based on Almaty Declaration of December 91, or we don't? So we have to clear that out. And only in March this year, just a few months ago, Armenia moved, after the insistence by Azerbaijan, Armenia moved to withdraw officially from the European Court of Human Rights that specific section of its application filed in February 2021, where it actually dedicated 12, 13 pages arguing against the Almaty Declaration. So that is a kind of sort of realities we're facing when it comes to our negotiations with Armenia, because obviously we are asking kind of questions that need to be answered in order for us to understand whether it is a genuine path to peace or it is just a kind of tactical decisions in order to delay the process. But still, the fundamental position would still be reserved for the future when good times come. And Armenia may come back and say, we have never taken that position. Whatever happened at the negotiating table happened at the negotiating. We never reached an agreement there. Hey, this is our position before the courts. We've never changed that position, which is not a hypothetical risk. So we are talking about quite a realistic risk here. And let me, given the limitations of time, so I don't want to hijack the agenda of my esteemed colleagues here, and then let some other issues for them to address. Quickly, I want to address 3 points that are advanced by Armenia against Azerbaijan when it comes to the issue of the constitution of Armenia, because it seems that Armenia is trying to dilute the essence and the importance of this issue by saying, well, this is an artificial point. Azerbaijan doesn't want to sign a peace agreement, so they never meant, although we started the process, although we've brought about 5 principles for the peace agreement. So this is just a tactical delay by Azerbaijan. And there are 3 points advanced by Armenia, given that today we have a somewhat new format where speakers from Armenia are also joining, which I believe is a good sign that we are moving in the right direction. So we hear each other's arguments. So I want to foreshadow some of the points that are raised. So the first, Armenia, after we raised the issue of the constitution of Armenia, after 2 years, they turned back and said, hey, wait a second, you also have some provisions in your constitution that we believe to be, would contradict the peace agreement if we sign it. And then we said, would you provide particularized, detailed provisions of our constitution or other legislative acts which would call on reunification of parts of Armenia with Azerbaijan? And then we got no response. So we don't have in our legislation any specific provisions similar to the legislation, to the constitution of Armenia, to the Declaration of Independence of Armenia, which calls on a reunification of parts of modern-day Armenia with sovereign Azerbaijan. It's simply not existing. And if it's there, I would still call on our colleagues to show it. Second, there's a proposal that once the peace agreement is signed, the Constitutional Court of Armenia could actually approve it. It would go to the Parliament of Armenia for ratification. The Parliament would need to get consent or opinion of the Constitutional Court in order to make sure that it is in line with the Constitution of Armenia. If the Constitutional Court of Armenia says yes, then it becomes yes. And that is the second argument used by Armenia in order to say, don't pay attention to our constitution, we will be fine. So we have at least 2 problems with this. Now, first, there was this famous case with the former president of Armenia, Robert Kocharyan, in 1997, 1998, when he was running for presidency. And under the requirements of the constitution, he should have lived within modern-day Armenia for at least 10 years, that national residency requirement. And obviously, he was living in Azerbaijan for most part, born and lived in Azerbaijan for most part of his life. And then they had to deal with that issue. How could you run for presidency? So allegedly, he won the elections. It went to the Constitutional Court, and the Constitutional Court, based on that declaration on the reunification of Karabakh with Armenia, at the time concluded that he met the residency requirement in order to be a president of Armenia. So that was actually used by the Constitutional Court in order to justify that. That's one. Second, the ICC, International Criminal Court, the Rome Statute. In early 2000s, it was open for the countries to accede to the Rome Statute. It also came to the table of the government of Armenia, and they had to decide whether they want to join the International Criminal Court Statute, the Rome Statute, or not. And then they took it to the Constitutional Court. And at the time, the Constitutional Court of Armenia said, you cannot join because it would contravene your sovereignty. You cannot give the jurisdiction over your nationals, which is a prerogative, the exclusive prerogative of your national judicial system, over somebody over there sitting in a Hague. So we cannot join the ICC. Fast forward 20 years, just 2 years ago, the Constitutional Court of Armenia, the same institution, had taken a completely different approach. Now saying you can join the International Criminal Court and providing its own justification for that. And I know that the justification is that the Constitution of Armenia were changed in the years between 2000 and 2022. And because of that, now you can. So the same institution took conflicting decisions. So could you actually rely on the Constitutional Court of Armenia if it tends to change, to shift its fundamental position at least once in 20 years? And the last point on this, when it is said that this is an artificial issue raised by Azerbaijan, show us some precedents. There have been precedents out there when the countries, in order to find to sign a peace agreement and pave the way for a sustainable future and peace here or in other parts of the world, they actually agreed to change their constitution because there were issues there. And there are at least three examples that I would like to bring up today. First is a famous Good Friday Agreement of 1998, where Ireland amended its constitution in order to remove its territorial claims over Northern Ireland. So they were given about 3-4 months following the signing, and as a result, those changes were made. The other famous agreement, the Prespa Agreement, 2019, Macedonia amended its constitution to adopt the name North Macedonia, given the claims that have been consistently raised by Greece in terms of its historic connotations of the word Macedonia. And currently, as we speak, there is Bulgaria-North Macedonia negotiations, which started 2 years ago, I believe, as part of the accession of North Macedonia to the EU. And Bulgaria demands that constitutional recognition of its ethnic minority in North Macedonia. The people that created North Macedonia have to include Bulgarians as a national minority. And I believe it is still on the table. So to conclude, we believe we have made remarkable progress after 2 wars, after aggression against Azerbaijan. As I said, it's been difficult times for this nation, but we do believe that peace and prosperity is our choice for the future. And we hope that based on the issues that I have covered today and our distinguished panel will be covering in the next hour, these voices will be heard on the other side, and these issues will be taken more seriously than they are taken today. And that would finally pave the way for the peace and prosperity in the South Caucasus, which is our choice. And we believe that's how the future of this region should look like. I thank.
Thank you very much. I think it was quite a good overview of legal issues related to the constitution of Armenia. And indeed, some of information first time for me, it's kind of new that with similar arguments, let's say in that way, on one table, Armenia speaks about the importance of Almaty Declaration, and in the court, at least they spoke otherwise. Thank you very much for bringing this and some other information to the table. Also, Mr. Mamedov mentioned some cases, European experience, and we, by the way, invited experts from Europe. We will have in the second panel former British ambassador to Azerbaijan, James Sharp. He's here to speak about how the Ireland and UK worked towards the Good Friday Agreement. And we have also experts from North Macedonia to speak about the experience related to the referendum and resolving issue with Greece. So that's, I think, quite relevant. Usually when we're doing something in Azerbaijan, we've been told that look at the Europe, this is the European experience, and we're trying to look at Europe, and that's the point, that the constitution must be changed in order to move with the peace process. So that will be the subject of our discussion during panel. So we will immediately start our first panel, when we'll have the coffee break and the second panel. In the meantime, I know the Deputy Minister is busy and he has some other events, so at some point he will leave this room. Again, please, I would like to invite our panelists to sit around table, and we'll start. We have Javid. Good. Javid, yes. Okay, so as I said, we're gonna have this panel focused on our Armenian constitution, and we have mixture. We have the member of parliament with also legal background, and we have a scholar who is teaching different legal subjects at ADA University, and we will have the also perspective from Armenia. The expert will be joining through Zoom. So our first panelist is Mr. Erkin Gadirli. I know him for many years, and actually first time we get acquainted even before our professional life at the courses of English language in the beginning of in the beginning of 90s. And
no, it was still a Soviet period.
You know, I think it was the 90s,
but anyway, more than
30 that's 30 plus years ago. And Erkin Gadirli also, as I said, has a legal background. He was teaching different legal subjects in Baku State University, in my alma mater. Also, he took part and been one of the experts of Azerbaijan delegation at different conferences, including ICC process.
I was a member of our delegation.
Yes. So floor is yours, and the subject is known. So also maybe you will tackle this issue from the point of view, how the parliaments can I don't know, contribute to that issue.
Thank you. Am I heard? Thank you, Barry. No. Oh, it's now, right? Okay, thank you. Again, thank you, Barry. Thank you for your invitation. Distinguished guests, ambassadors, Mr. Deputy Minister. I see colleagues from the Parliament as well. After such a brilliant presentation by the Deputy Foreign Minister, not much is left for us as lawyers to speak about. But on the positive side of this, I feel more relaxed now. And I want the audience to be relaxed too. And as Farid mentioned, I am a lawyer, but I never practiced law. I had an academic background. I used to teach at the Baku State University. I would like to start with an anecdote, with your permission. Lawyers have a lot of cynical anecdotes about their own profession, and I would like to share with you one of my favorite. Imagine a person who drives a car in a city which he doesn't quite know well, and then he gets lost. And he sees a pedestrian and decides to ask for a direction. And he asks, "Excuse me, could you please tell me where I am now?" And the pedestrian tells him that you are in the car. And then the guy says that you must be a lawyer. He said, "Yes, how did you know?" And he said, "Because your answer is correct, but absolutely useless." It is indeed, there is a long-standing and endless disputes between politicians and lawyers about what is possible and what is not, what is allowed, what is not allowed, what is necessary, what is not necessary. So it's endless, and it's everywhere, in every country. So here the situation is this, like where the first panel is dedicated to the legal aspects of it. And we have the situation when, as our Deputy Foreign Minister already mentioned, when Armenian constitution, in its preamble, has a reference to the Declaration of Independence, which itself contains a clear territorial claim towards the sovereign territory of Azerbaijan, because it refers to a joint resolution of then the Supreme Soviet of Armenian Socialist Republic and the Regional Soviet, as the council was then called, of the former Nagorno-Karabakh Oblast. It's about reunification. And since Armenians always say that they never officially recognized Karabakh as part of Armenian territory, which is I have a trouble to agree with. In fact, officially and indirectly, they made moves to make it clear that they do recognize Karabakh as a part of Armenian territory. You know, there is a document called International Covenant on Civil and Political Rights, and every member state is supposed to provide a periodic report to the International Human Rights Committee. And in the 90s and early 2000s, Armenia always wrote in its report with regard to Article 1 of the Covenant, which stipulates the right of all peoples to self-determination, that Armenia protects the right of the people of Nagorno-Karabakh to self-determination. And the International Human Rights Committee always replied in its general comments to Armenian government that Armenia is supposed to provide reports only with regard to its internationally recognized territory. So international community never recognized Karabakh as part of Armenia. Armenian politicians also seemingly never recognized it, but in certain international procedures, they did attempt to do so. So that shows clearly what their intent was about. Now today, when Azerbaijani government, and it's not just the government, you should understand perhaps that this is a general expectation of our society, because I do not represent the government. In fact, I am in the opposition to this government. But there has always been a general expectation of this country. All political forces agreed on the certain modalities of resolution of the conflict. It is unfortunate that we had to have recourse to use of military force, but that's only because the peace talks or peaceful settlement of the dispute was never possible. But now peace is somewhere on horizon, but horizon is a very tricky concept. You always go towards it, but you never reach it. Now, Armenian constitution, this reference which the preamble contains to the Declaration of Independence, is very troublesome. You know that there is a constitutional opinion. The Constitutional Court of Armenia now provided an opinion on that preamble, which is, in fact, itself very difficult to understand. If you read the Constitution of Armenia, it clearly says which articles and chapters cannot be amended at all, which articles and chapters can be amended only by referendum, and the rest can be amended by the parliament. Now, preamble is not mentioned anywhere among those provisions. So logically, we faced three options. Preamble can be amended, cannot be amended. Preamble can be amended only by referendum, or preamble can be amended by the parliament. Unfortunately, the Constitutional Court of Armenia opted for the first possible solution and decided that preamble cannot be amended at all. And by doing so, the Constitutional Court of Armenia made the situation even more difficult, because previously the demand of Azerbaijani government was focused only on the preamble, and not entirely on the preamble, but on that particular phrase which referred to the declaration. So we're okay with the rest of the preamble. What we expected from Armenia and demanded from them is just the deletion of that particular phrase. But after the decision of the Constitutional Court, which stipulates now that preamble cannot be amended, now the demand of Azerbaijani government consequentially is all about now constitutional redesign of Armenian society, which we never envisioned, because Armenia put itself in a very difficult situation now. They cannot amend the preamble within the framework of the present constitution. But to get rid of that preamble, they will have to adopt entirely new constitution. Well, I hope if they ever decide to do so, they don't do it in the French way, because if you know, France, when they adopted their constitution in 1958, they decided that the preamble of the constitution of 1946 should remain in force. Again, we have no interest in constitutional design of the Armenian society, but the Constitutional Court of Armenia now put the entire country of Armenia in a very troubling situation. And to be honest, because I don't represent the government, I'm not a participant of the negotiations. I don't know what's on the table right now and how the government is now negotiating this particular aspect of this problem. But I can assume, as a lawyer, that if a constitutional change will remain a valid claim from the Azerbaijani government, then there is only one solution: is to change the entire constitution of Armenia. Unless, which is another perhaps positive aspect of a negative situation, Constitutional Court of Armenia decides to change its own decision. This is, by the way, one of the reasons why we do not trust Armenia when they say that now we have constitutional judgment, and the Constitutional Court decided that this agreement on the Joint Commission on delimitation of borders does not contradict the Armenian constitution. And we say, no, this is not a guarantee for peace, because any future composition of the Constitutional Court may decide to revise this decision. And then we're stuck again. There's one hypothetical solution as well. Let's imagine that the Armenian side offers such a solution. What if, they might say, they abolish, they null and void the declaration itself? There is a formula, the maxim, which in Latin goes like cessante ratione legis cesset et ipsa lex. In English it means when a reason for which a law was adopted ceases to exist, then the law itself becomes ineffective. So, in other words, if a declaration of independence, if Armenia decides, because it was adopted by the parliament, if the parliament of Armenia decides to null and void the declaration itself, then the preamble to that declaration becomes empty words. But I'm inclined to disagree with that hypothetical solution as well. Because Declaration of Independence is a single historical act full of wishful thinkings, but those wishful thinkings may lead to anywhere. By the way, distinguished Deputy Minister of Foreign Affairs, mentioned Armenian claims, reciprocal claims, or what they believe to be reciprocal claims towards Azerbaijan, when they say that Azerbaijan also should change its constitution, because Azerbaijan constitution preamble contains a reference to the Constitutional Act on State Sovereignty, which states that the Republic of Azerbaijan, the Azerbaijan Republic, is a successor state of the First Republic, which existed in 1918, 1920. Now, as a lawyer, I have to say that that particular phrase in the Constitutional Act of Independent State Sovereignty, adopted in 1991, October 18, has never meant to have a legal effect or consequence. Because according to the international law of state succession, there are several concepts which we have to take into account. One is a date of succession. Date of succession is a date upon which a successor state replaces a predecessor state. Now, that date is quite often not immediate, because it's understood that it can take some time for a state to prove its statehood and to get recognized. So a couple of years may pass, maybe longer, I don't know. But it should be a reasonably short period of time. Now, in our case, the Republic, which ceased to exist in 1920, and the Republic which reappeared in 1991, we have a 71 years time gap. This time gap is neither reasonable nor short. So you cannot speak about date of succession in this particular case. There is another concept which is very important to take into account, and that's the concept of newly independent state. It is a spatial criteria. Newly independent state in international law, in the Convention on State Succession, means a successor state which territory immediately before the succession belonged to a predecessor state. Now, here we have, again, the criteria of immediate. And here's why, for example, when Azerbaijan Republic reestablished itself in 1991, the territory which it had legally was a territory which immediately before the independence belonged to the Azerbaijan Soviet Socialist Republic. And here's why Almaty Declaration becomes relevant and the uti possidetis principle becomes effective, as distinguished Deputy Minister rightly mentioned in his presentation. But then again, Armenian side claimed that Karabakh never was a part of Azerbaijan, and when Almaty Declaration was adopted, Karabakh already declared its own independence and then joined with Armenia, and so in effect it was not part of Azerbaijan, which is legally a nonsense. Am I running out of time? Okay, which is legally a nonsense. So with regard to the modality of conclusion of peace treaty itself, according to Armenian constitution, it should be, Armenian constitution says that upon the recommendation of the government, the parliament decides on establishing peace. That's declaring war and establishing peace. The formula that is used in Azerbaijani constitution is slightly different, more archaic, I would say. Upon the request from the president, as the parliament authorizes the president to declare a war and conclude peace. It's a very archaic formula, which never used nowadays. Since the end of World War II, there have been several hundreds of conflicts, interstate conflicts and internal conflicts. And according to the UN statistics, around 15 or something % of those conflicts ended with peace treaty. And that is why states no longer declare war. Historically, this precedent first happened at the end of the World War I, when all the parties to that war, when they concluded peace treaty in Versailles. America also signed that treaty, but the Senate, Woodrow Wilson, a Democratic president, signed it. But the Senate was controlled by Republicans, and the Senate refused to ratify the peace treaty signed by the president. And then America found itself in a very strange, and I would even say an absurd situation, because all the parties to the World War I concluded peace among each other, and the only remaining country at war was America. And the question was with whom America was at war. So then the president decided to declare peace. And that's the competence that American Constitution does not provide. And it was disputed, and the Federal Supreme Court of the United States had to consider a commercial case, by the way. A company sued the government because during the World War I, companies were under certain restrictions with regard to international trade. And then when the war was over, one of the companies sued the government by saying, if the war is over, then the restrictions should be lifted. If the war is still ongoing, then whom we are at war with. And then having had to decide that particular case, the Supreme Court of the United States had to approve the newly acquired competence of the American president to unilaterally declare peace. The reason why I mention this is because when Armenians signed, we hear sometimes that, okay, Pashinyan is in a very difficult situation. Opposition is pressing. There's a foreign pressure as well. What if he fails to get a treaty ratified in the Armenian constitution? This could be one of the solutions, because officially, neither Armenia nor Azerbaijan never declared war towards each other. But this is all academic presentations and more or less hypothetical solutions. What is really needed to decide upon is that how do we do with the current situation after the decision of the Constitutional Court of Armenia, because it made situation even harder, because now the parliament cannot amend the preamble, and it cannot be amended by the referendum as well. And now it seems like when Azerbaijan, the government, demands from Armenia to amend a constitution, it seems like Azerbaijani government demands from Armenia to change its constitution entirely, which has never been our intention. So I'll probably stop here. I hope there will be questions. Thank you very much.
Yeah. Thank you. Thank you. Indeed, it was interesting, some points. I would like to save some space for Q&A, so that's why I would ask to keep the limit of intervention. Now we have, so as I said, we tried approach differently with event. So we had government view, we had from opposition, we'll have now from academic, more the who is teaching in. So Javid, please, you can take floor there, or yeah.
Okay, now it works. Hello. Thank you. Very nice. So I will probably jump straight into the decision of the Constitutional Court of Armenia concerning the territorial claims contained in the U.S. Constitution. In the Armenian Constitution. And so let me just basically, continue what Professor Gadirli already said. So in its decision, actually, the decision was delivered on September 26 September 2024, and it reviewed the constitutionality of the regulations of the Joint Commission on delimitation and border security, the one which is concerned with the delimitation of state border between Azerbaijan and Armenia. And basically, the court examined whether reliance on Soviet-era borders of 1976 military maps, as per Alma-Ata Declaration of 1991, and Armenia's engagement in the delimitation process is contrary to the Armenian Constitution. And in short, the court rules that the regulation was constitutional, so it's not contrary to the Armenian Constitution, and affirms that Armenia's participation in the delimitation process based on the Soviet-era borders did not violate the Constitution. In doing so, they had to interpret the legal effect and the role of the preamble to the Armenia's Constitution, which, as was mentioned, refers to the Declaration of Independence of Armenia, which contains reference to the 1989 Joint Declaration on reunification. Let me actually, on the reunification with, this is the back, yeah, okay. Let me, yeah. So, yeah. Speed up. Yes, I'm trying. So decision highlights, so they had to deal with this reference to the territorial claims towards Azerbaijan contained in the Armenian Constitution. And what the Constitutional Court said was that they are symbolic and ideological, but and they are unenforceable. So declaration on reunification, which is contained in the preamble, has no binding constitutional force. But this ruling is actually quite narrow. So it focuses only on the Delimitation Commission agreement, and it doesn't envisage renunciation of these claims. And in fact, the territorial claims there, they remain unaltered, and they are central to Armenia's constitution. So delimitation doesn't ensure that a peace treaty renouncing claims would similarly be uncontested in the Constitutional Court in the future. The provisions which are in the declarations were held by the Armenian Constitutional Court to be unamendable provisions, so it's impossible to amend them. In fact, the Constitutional Court says that entirely new constitution will have to be adopted to remove them. Yeah? Okay, so these are actual conclusions. Let me go to the okay. So the key question for my presentation was whether Armenia's constitutional and legislative provisions create obstacles to a peace agreement with Azerbaijan. I believe they do. So I will not talk about territorial claims to Karabakh that Armenia has or its occupation. It's been covered. Yeah. Okay, let me go. So why this potentially might be a problem? Under the Vienna Convention of the Law of Treaties, if there is a peace agreement concluded between Azerbaijan and Armenia, it might be contrary to the Armenia's constitution. Now, that might create a problem for these treaties. So treaty cannot be, according to the Vienna Convention, invalidated based on domestic law unless this violation is manifest and it concerns a fundamental rule of internal law. Now, both of these conditions might be met in the case of Armenia, because preamble and territorial claims, they qualify as fundamental rules, rules of fundamental importance, and this actually has been underscored in the Constitutional Court's decision, and they might create conflicts with the treaty obligations if such treaty is to come into effect. And okay, so okay, let me go back to the court's position on territorial claims. So in its decision, Armenian Constitutional Court highlighted that territorial claims are, as I said, symbolic and ideological, unenforceable, and it has, this reunification declaration has no binding constitutional force since the declaration itself is not integrated into the constitution. So it's only referred to, yeah? So it's not binding, but again, you know, instead, okay, so several things actually what the Constitutional Court did there. Once they said that these claims are integral part of the Constitution, they are unamendable, they're of the highest normative value. In fact, they say that this is a decision made by the constituent power. So this is the highest importance in the Armenian Constitution, and the Constitutional Court cannot remove them, which is in a way true. Constitutional Court has no authority to remove and edit at its will the Constitution of Armenia. But what they said that it's not an obstacle to the delimitation commission. Yeah. So does this clear, so to speak, the concerns? I argue that it doesn't. Firstly, because it's very narrow. It is about delimitation commission, but not renunciation of claims altogether. So just because the regulations on the delimitations are not contrary to the Constitution doesn't mean that total renunciation of these claims, which is probably going to be envisaged in a peace agreement, will also be not contrary to the Constitution. Actually, it is quite likely that it will be challenged. And another consequence of the ruling of the Constitutional Court is that actually these claims are going to be preserved in the Armenian constitution, and they will remain central to it. Yeah. So in short, delimitation doesn't ensure that a peace treaty renouncing claims would be uncontested. So so what are the challenges to the peace agreements that remain? So firstly, there are unamendable provisions now of the highest constitutional value. So it is, of course, slightly strange that the highest constitutional value is territorial claims to another state, but okay. Peace agreement renouncing these claims is unlikely to withstand scrutiny by the Constitutional Court in Armenia. And as mentioned by earlier distinguished speakers, Armenia's stance on uti possidetis iuris, also in the European court cases and otherwise, sometimes allows it to accept Almaty Declaration without acknowledging Azerbaijan's territory, right? So it is not necessarily a very good faith approach. So I argue in my very brief, in a brief which is linked in the QR code, by the way, that a comprehensive peace agreement actually requires constitutional repeal of territorial claims. And this cannot be achieved by a decision of a constitutional court. Yeah. So does the decision of September 26, 2024 clear the obstacles? No, the court actually avoided addressing constitutional claims territorial claims to Azerbaijan directly. And these claims remain entrenched, meaning that they cannot be removed, amended, repealed. So even constitutional amendment will not suffice now, what the court says. And as having the highest constitutional force according to the Constitution of Armenia. So in a way, they made it more difficult for the government to renounce them. Yeah. So what is needed then for a peace agreement to be successful? Well, it appears that Azerbaijan can either close the eyes, so to speak, to this potential, flow in the Armenia's consent to be bound by the peace treaty, or has to expect that Armenia will basically repeal these provisions, which is, according to the Constitutional Court, only possible by adopting an entirely new constitution. So this is necessary to reconcile constitutional values with the practical peace objectives. So I'm sorry that I scrambled my presentation somehow because there were so many issues raised in the previous two ones. But if you are interested to read my brief on the decision of the Constitutional Court of Armenia, you can read it. It is quite short, actually, won't take much of your time. Yeah, so basically there I review the decision and what kind of, does this decision actually clear the obstacle to the peace agreement or not? Yeah, so my preliminary conclusion is that it doesn't actually. So there are on several levels. First of all, I don't think this issue should have been left to the Constitutional Court. Yeah. So secondly, Constitutional Court has a limited mandate here. It cannot change the Constitution. It can reinterpret it, but when it was interpreting the Constitution, it actually elevated these provisions to be of the highest constitutional value and says that they cannot be removed, they cannot be, and they're superior to all others. So the whole Armenian constitution, in a way, now has to be interpreted in the light of these provisions. So, yeah, that's where we are left off. I'm happy to read you.
Thank you.
To receive your opinions on this and questions on this. And
thank you very much. No, I think everything. I know there's too many technicalities on legal technicalities, sometimes hard to digest for people outside of the legal domain. But anyway, because the issue is indeed very sensitive and important for the peace process. So I think, I believe it's important to have this kind of the perspective. But we're going to also talk a bit about politics, and during Q&A, maybe you will have questions, and we have all representatives here. So now I would like to ask our technical team to connect our Armenian speaker. Hello? Onik?
Hi.
Do you hear me?
I can hear you.
First of all, thank you very much, Onik, for agreeing to be part of this discussion. I would like to tell to the audience that Onik Krikorian lives now in Georgia, in Tbilisi. I tried to reach out to some people from Armenia. Unfortunately, for different reasons, some people were busy. Anyway, I got negative replies. So I quite appreciate, Onik, for your readiness to join and speak. And I hope that will be kind of a new paradigm of discussion of the issues which are important for the whole South Caucasus, including for Armenia and Azerbaijan. We just to brief you, we had Azerbaijani perspective, government and academic perspective on why we believe that the Armenian constitution is important to change Armenian constitutions, to amend and to remove territorial claims. we hear different perspective from Armenia. Maybe you will give the overview, and then during Q&As, we have here representative of diplomatic corps and academicians from Azerbaijan. Will be some more questions about the situation in Armenia, and you free speak about also the political situation, not only legal affairs. Floor is yours, Onik.
Okay, thank you very much, and thank you for this invitation to participate. I haven't prepared a presentation, sadly. As you know, Georgia at the moment, Tbilisi, is in the midst of utter turmoil, so that's been preoccupying me. I'm not a lawyer also, and I can't really speak about the legal aspects, but just to say, I speak here not as a representative of Armenia or Armenians, but as a journalist of part Armenian descent who's lived in Armenia, observed constitutional processes there, and am now again regularly reporting on the Armenia-Azerbaijan conflict. I joined this panel late because there were technical problems apparently. So I only got a bit of what Mr. Gadili said. So I don't know what was said before. So I think first of all, you have to understand the history of referendums in the Republic of Armenia. The constitution, by and large, doesn't mean much to people until now that it's become an issue in Armenia-Azerbaijan normalization. Some of you may know that in 2003, President Robert Kocharyan tried to amend the constitution, and it actually failed because of the number of people that, I think it was turned out. I think that the amendments kind of passed with a very slim majority, but there weren't sufficient number of people to make the referendum valid. That was followed up in 2005. And that time it was passed, but ironically, and I was observing that referendum in Armenia, there were empty polling stations across the country. I mean, some cases literally totally empty. Other cases it was just a trickle, and yet the government declared that it was the largest turnout for a referendum ever in the Republic of Armenia. This has led to, for those people who are aware of the constitution, led to a lot of mistrust in constitutional referendums anyway. It also had to be submitted to the Venice Commission. The Venice Commission hasn't always been happy with a lot of the referendums, so there's that aspect to keep in mind. And in 2015, then there was another referendum under then President Sarkisian, and it also passed, but again, it was accompanied by a lot of controversy because, of course, Armenia switched from a semi-presidential system to a parliamentary system, and this was widely seen to be a way for Sarkisian to maintain his power once his second and final presidential term had expired. He rejected that allegation, but of course, as we saw, that's what happened. It should also be remembered that it was precisely that, and Sir Sarkisian taking power as prime minister in 2018, that led to the quote-unquote Velvet Revolution that brought Nikol Pashinyan to power. They didn't want a continuation of Sir Sarkisian's rule. So constitutional amendments have always been controversial in Armenia. And I think that when President Aliyev, I guess it was earlier this year, made it a demand, of course it had been referred to before, made it a demand, my first reaction was, this is not going to work. Because in order for a constitutional amendments to be passed, you do have to have a certain amount of people turn out for a referendum, even before you get to the point of whether they vote yes or no. And this is another interesting thing, is so far constitutional amendments have been yes or no, rather than certain points listed for voters to choose which particular points they want to change. Now, Nikol Pashinyan has been genuine in wanting to change the constitution since before the 2020 war. If you remember, he wanted to change it in early 2020, but the COVID pandemic disrupted things and it had to be cancelled, or rather postponed. And the idea was for it to be postponed until 2021. But then, as we know, after the 2020 conflict, we had snap elections instead in the Republic of Armenia. Nikol has set up a special panel or group in order to discuss constitutional amendments. Last year, he was quite controversial in raising many issues about certain aspects of the constitution that he himself said prevent us from living in peace with our neighbors. And he continues in that vein, even so much as questioning the coat of arms, for example. So I think that Pashinyan, and I have plenty of things to say that what I don't like about Pashinyan's rule or mistakes that have been made in this negotiation process, but I do believe that Nikol Pashinyan is genuine about this. And at the beginning of the year, on a visit to the Ministry of Justice, he also said that maybe I think we need a new constitution, like just rewrite the whole constitution, which of course is going to take time. So going back to what I said about when President Aliyev spoke about making it a demand, not so much like we'd like it changed, but there's no peace treaty unless it's changed. I was a bit shocked by that, and also felt as though it risked damaging the whole peace process, as Ambassador Sharp knows, because we had an exchange on Twitter and via private correspondence as well. But I will admit that perhaps I was a little wrong in jumping to conclusions, because Ambassador Sharp was talking about, for example, the Good Friday Agreement. And you yourself, Farid, and I know other analysts in Azerbaijan have discussed how a referendum could be delayed until a later date. Also bear in mind that there needs to be a lot of discussion in Armenian society. I think that the Azerbaijani government have said that it wants this by referendum because it needs to be sure that as Armenian people have decided that it is time to find peace with Azerbaijan. But the problem is it's a highly charged political situation in Armenia. Referendums have never really had a good history in Armenia. And so I just think it should be a little bit more of a cautious approach. As I said earlier, I lived in Armenia for 12 years, and I was there for the 2005 referendum. But I tended to get the impression that no one really cared about the constitution because they felt the constitution never worked for them under the previous two administrations to Pashinyan's. And there was a point I was going to make there. Okay, sorry, I forgot my point. But the point is that Nikol Pashinyan, I think, wants a new constitution. It seems to be when he came to power, he wants, in a sense, to create a new Armenia that is disassociated with the two previous regimes. So I think he's genuine. My point was that now it's been raised by Azerbaijan. Suddenly people in Armenia are now talking about the constitution. And from the Armenian perspective, rightly or wrongly, that's neither here nor there. But suddenly now people are speaking about the constitution. And if we remember, there was a poll earlier this year, and something like 88% of respondents said that we reject any idea of changing the Armenian constitution. There's a few more points, but I think it was Mr. Gadili said that Armenia needs a new constitution. This seems to be what Nikol might be aiming for. Unfortunately, is that those of you who might have read my two pieces in Baku Dialogues, the point is we never really know what Nikol is planning, and sometimes it can change as well. And he's a good orator. He's a good populist. You can see in his speeches that it seems to me, I don't know for sure, that he's preparing people for some kind of changes. In his last press conference, he was mentioning referendums twice to change to put in the constitution various other changes. Or to change legislation that was quite unexpected. As you probably know, there's the issue of the EU referendum in Armenia that's being discussed. Doesn't matter that the EU hasn't invited Armenia to apply, but this is also being discussed in Armenia as well. I guess I'll leave it there. Oh, there's just one point about one thing that's confusing for me is I think Azerbaijan says it needs a new constitution because the preamble cannot be changed. But from my understanding of looking at the text, it's only points 1, 2, and 114 that can't be changed in the constitution. So I'd like maybe someone to deal with that. And I'll leave it there, and I'm sure more points will come up.
Well, thank you very much, Onik, for this. Please stay with us because we're going to have Q&A session. Okay, Erkin would like to answer. Okay.
Sorry for taking the floor. Oh, Onik left? Onik, are you with us? Or you left?
No, I'm here. I just turned the video off.
Very brief. I know the original text of the Constitution, yes, you're right. It enumerates certain articles and chapters which cannot be amended, and preamble is not among them. But it was the Constitutional Court in its judgment which stipulated that preamble is unamendable. So that was my point. Thank you.
Okay, thank you. Just my one of the ideas which coming from this Good Friday Agreement. I don't know whether it's workable or not, because now Onik's saying this is the now political issue. But as I think everybody now heard what Deputy Minister said and two legal experts, that for us it's indeed essential issue, because in the future might be different governments saying, you know, everything which Pashinyan said or he did, it's null and void, and we still have the Armenian constitution as the highest possible, I mean, this is highest legal document. So in that sense, I know that in British-Irish approach was not amendment referendum before the signing. It was signed and the referendum happened after that. James Sharp will be speaking about that. But that obligation was enshrined in the peace treaty. I don't know whether this is something also we can think about. Okay, floor is open for the question. Yes, Ambassador of Kazakhstan, please. Microphone. Thank you. Maybe, Elnur Malim, I invite you to sit down here for if someone will come, or, yeah, to answer. But maybe you will answer the part of about where we now. But I'll try to answer why we organized this event. First of all, I follow the media, and this is what the think tanks do, and a lot of distorted, biased coverage, especially in Western media, that somehow Azerbaijan is delaying peace process, and that the issue of constitution is something which made up. And so that's why we decided to bring government experts, opposition, members of parliament, and also bring European experts. First of all, to give legal analysis that the issue of constitution indeed has very far implication. And the second issue, but how we can resolve this issue. So that was my idea, or our idea, why we organize it right now. But with regard to the peace process, that I will leave to Deputy Minister if he can speak. I know there's some confidential moments, but at least what can be available to the public.
Yeah, thank you. Good to see you, Ambassador. Thank you for the question. So I could probably comment on things that are in the public domain. So for the reasons you understand, and that is our agreement with the Armenian side that we won't be leaking what could be damaging at this point. So what was or is in the public domain is the fact that there were discussions about the new constitution of Armenia to be proposed to be adopted sometime in 2027. That came from the Prime Minister Pashinyan. In addition to that, the kind of arguments used by our colleagues in Armenia are the Constitutional Court opinions or ratification or adoption of approval of the potential peace agreement. Once it goes to the parliament, it would then go to the Constitutional Court of Armenia, and then with the approval of the peace agreement by the Constitutional Court, which is a prerequisite for the ratification of the peace agreement by the Parliament of Armenia, that would answer all the questions and address all the concerns of the Azerbaijani side. But I believe we've spent an hour today in order to explain why it doesn't actually address the concerns that we have on our end. So I think it's up to the Armenian side to comment what they plan to do, but that is what we know from our interactions, from our conversations, that currently there's not an immediate plan to do it. We understand, and there are not other solutions on the table that were specifically discussed or proposed to address this. And that is exactly why we're here discussing and bringing this up and explaining our perspective, why bolder actions need to be taken by the Armenian side in order to address these concerns.
Thank you. Any other questions, comments? Yes, please, Ambassador of Croatia.
To me. This one thing, and another thing probably for Deputy Minister Mamedov, I'm sure that the Azerbaijani government looked at the history of other cases. So I think there are many, probably many, so maybe you can answer, maybe cases that there was no ever signed peace agreement, but things are going on, and do you think that this is possible also in this case between Azerbaijan and Armenia? Thank you.
I'll let Deputy Minister to answer, and then we'll ask. Yeah.
Thank you, Ambassador. I realize I should have left earlier because it's getting complicated. So first, on the question of how could we find the way out? That is a question. That's exactly why we're discussing this. We're getting to the finish line on the text of the peace agreement, and that brings up the issue of the Constitution of Armenia once again, because we've been discussing this for probably 2 years now. And as you're reaching this finish line, we have to find a clear response to that question from the Armenian side, what is planned on the other side in order to address this concern. So we don't know. So I don't want to speak to what the Armenian government may want to comment on this issue. I don't want to sort of cross that line and start getting into speculations, but we have to find an answer. So, and the answer is on the other side of the table. In terms of, we have been commenting, we have been saying that we actually have the de facto peace now. If you look at the border situation, the no skirmishes, it's been stable. We're working on a delimitation and demarcation of the border. We have had quite a significant progress now. First time in the history, more than 10 kilometers of our interstate border is delimited and demarcated. The regulations have been approved by the governments of both countries. And as such, we are moving in the right direction. But of course, in order for you to eliminate all the possible risks and situations, especially with the change of the government in the future, you would like to have assurance that this is a done deal, not only for the current government, not only for the current realities in Armenia, but this is a decision by the people of Armenia, by the state of Armenia, by the Republic of Armenia. And that is kind of assurance that we're looking forward to receive from the other side. But in terms of what the situation looks like now, you could probably refer to it as de facto peace. It's a situation that both countries have been enjoying for some time now, and it's obviously something that we could celebrate in a sense.
Thank you.
Thank you for your question, Mr. Ambassador. Yes, as we all know, there have been many different examples of ending war, and with the peace agreement, without peace agreement, under the umbrella of some international organizations, or by mediation by some international actors. All of them are, they're relative to a certain place and time. So you cannot just copy it. For example, yes, United States never signed peace treaty with Germany or Japan, but America simply effectively occupied those territories, wrote down the constitution for them, and then left and turned them into their own allies. So that example is clearly non-relevant for us. The former Yugoslavia, there was a peace treaty, the peace conference for the former Yugoslavia, and the well-known Badinter Commission, and all the criteria that they wrote down, but things went out of hand, and the war broke out. So those criteria, unfortunately, the conference couldn't apply them. But then, of course, in our case, for example, international community could have thought about creating certain motivations for both countries to solve their conflict peacefully, but they didn't. For example, Azerbaijan and Armenia were admitted to the Council of Europe together, but without solution. For example, the Council would have said them, no, you first should solve the conflict and then become a member of the Council of Europe. That could be motivation. Or OSCE or any other. European Union is non-relevant for both of our countries. We're very far away of meeting any criteria of becoming a member of the European Union, and even the European Union is not interested in accepting us as a member. So that's also non-relevant. So, and Minsk Group, yes, we have this experience, but Minsk Group failed to mediate peaceful solution of our conflict. And now we are at a situation when, for example, at least the Azerbaijani government says that we do not need mediators. Let's talk to each other directly. And it is very good that we now have precedents, and we have examples of direct communication between the government of Azerbaijan and Armenia at different levels, both open public to the public and confidential. The one which is open to the public in this joint commission on delimitations, and we already have some positive results of it. So yes, I think we are now on track of solving our problems without any mediation, and that is why we have this additional problems, meta problems with constitution arrangements. Thank you.
you would like to add something?
Yeah, thank you. So, on the issue of the peace agreements in general, there of course take various forms, right? So ranging from, I don't know, genuine interstate agreements, Cambodia Peace Accords or Dayton, which was mentioned, Good Friday Agreement, constitutional amendments could be included as a package. They typically solve a comparable set of issues. Sometimes the international organizations heavily intervene, such as the UN Security Council did, for example, in the Washington Agreement, in the case of Croatia. But what I'm trying to say is that although the set of issues which is typically settled, sometimes they're informal under international law. They could be supervised, but for various reasons by I don't know, non-state church, for example. In some cases, in Angola, for example, they did that. But the point is that the territorial claims are the heart of this conflict. So, and it is not something which is an imaginary or hypothetical concern for Azerbaijan. For 30 years, it has been the very reality. The claims. And so I think it is one of the essential basis. It is the essential basis of consent to be bound by any agreement between Azerbaijan and Armenia, is the renunciation of claim. And it's both for Azerbaijan and for Armenia, actually. So if this claim isn't removed, the other things are more or less, I wouldn't say trivial, there are lots of important things happening there, but this is an essential point that we have to be clear about it, and it's not something, which is, spooky in the air.
Yeah, I think indeed a very important question is indeed what Javid said, that the territorial claims at the heart of this conflict. Before giving floor to Onik, maybe he has his own thought, whether Armenian society may be ready to live without peace treaty. They want peace, or they are also okay with that situation, no war, no peace. Just an example, recently was the OSCE ministerial meeting in Malta. And Armenian government, Armenian delegation insisted on keeping the Minsk group. And you know that the Minsk group was created specifically for resolving this conflict. So you see, you can say it's mistrust, but Azerbaijan has every reason to believe that on one side where the Armenian government speak, okay, we don't have any claims, we honor Almaty Declaration, and let's move further. And in the meantime, in OSCE, we're trying to keep the Minsk group quite defunct institution, because since 2020, it has no single meeting. And can you imagine now, United States and Russia sitting down to resolve something, and France, Onik, floor is yours. Maybe you have some feedback, and we'll wrap up and go for a coffee break.
First of all, it's really encouraging to hear that the Deputy Foreign Minister believes that things are moving in the right direction. And yes, the idea of de facto peace seems to be in place. But I don't really see how that would change if changing the constitution doesn't happen, because it will still be the same situation, and still Armenia and Azerbaijan cannot agree on the necessary next steps. For example, like, I don't know, unblocking regional transportation. I don't see that nothing really changes there. But just a point about the constitution itself. The problem is not really so much that the constitution might have to be changed, because Nikol Pashinyan wants to change the constitution now, but he needs time to do this. And I think we can see signs that he's preparing people for this change in mentality. He's already said this. The Armenian people, as such, according to the last opinion poll, 55% said they want peace with Azerbaijan. It doesn't sound like a lot, maybe just over half, but it's only a few years since the 2020 war. But that's quite remarkable if you might consider the trauma that was inflicted on Armenian society. And yes, I know trauma was also inflicted on Azerbaijan society beforehand as well. The problem is that if you want the constitution to be accepted by the population of Armenia, it probably shouldn't look as though it's being forced by Azerbaijan. And I think that this is probably one of the reasons why the Armenian government isn't showing itself to be so keen to accept this as a precondition, because it seems like a precondition, and it's meant to be for the Armenian people. So I don't think that that's a particularly productive approach. I do think the idea is wait until 2027. Someone I interviewed in Armenia for a recent article about these constitutional discussions is that probably Armenia wouldn't anyway need a constitution in order to have territorial claims or indeed to fight a new war. If it feels strong enough and if the government wanted to do this, it would do it anyway. Certainly, I don't see that situation emerging anytime soon. And I also think that probably a good thing to do would be, one, not to make it seem like such a demand on the Armenian government. And secondly, there's an urgent need for confidence-building measures. It's clear there's still a deficit of trust between the Armenian and Azerbaijani governments, but also very little is being done in order to promote trust and confidence between the peoples of the two countries. So I think the idea of just preparing the ground for 2027 might be a better way to do this. But if the constitutional amendment can't be agreed, I think probably people need peace more than they need a situation of no peace, no war, effectively the situation that we had before 2020. Only Azerbaijan has its territories back, etc., etc.
Thank you. I would like to thank all panelists and also Deputy Minister for his keynote intervention. I hope that you enjoyed discussion and found it useful. So we'll have 15 minutes coffee break and come back for the second panel. Thank you very much.
Excellencies, ladies and gentlemen, dear audience, would you be so kind as to make your way back to the seats so that we can begin our second panel? Thank you. Excellencies, ladies and gentlemen, let's see if we can do this on the third attempt. Would you please be so kind as to take your seats and put your coffee cups down in those magnificent sandwiches that the Hyatt folks have produced. Please take your seats so that we can begin, so that we can end on time. Thank you very much. Okay, thank you very much for having taken your seats. Means I don't have to ask for the fourth time. Okay, let me begin with a couple of things. First of all, Ambassador Sharp has a PowerPoint presentation or something. So whoever's in charge of that, please put it up because we're going to get to him in a moment. Second, again, to remind you, the title of this conference is The Main Obstacle to the Peace Agreement between Azerbaijan and Armenia. And we had a keynote speaker in the form of the Deputy Former Foreign Minister Mamadov. We had the first panel that focused on the legal interpretations and understandings of this chain of documents that begins with this unification declaration, then the Declaration of Independence, and then the Armenian Constitution. We are now going to move in a slightly different direction. The title of this panel, of the second and the last panel, is Changing Constitutions for Peace, International Experiences. And maybe perhaps one way of, or another way of using this subtitle is to say international best practices. We're going to have this discussion in the following way. We will have the UK's former ambassador to Azerbaijan, Jamie Sharp, who is going to talk about, as far as I understand, the Irish experience or the Irish best practice. Irish, not in the national, but in the, all right. Second, we're going to have Mithat Çelikpala, who's a vice rector of Kadir Has University in Turkey, who's going to offer a Turkish perspective on, again, this chain of three documents in the context of the Zurich protocols and perhaps in the context of what is to come once the peace is signed between Armenia and Azerbaijan or not. And then the third way we're going to have this conversation is by asking Zhidas Daskalovsky, who's a professor of political science and director of the Council of Europe supported School of Public Policy in Macedonia, in North Macedonia, who is going to talk about the Prespa process that led to the Prespa agreement, and then perhaps some other things. And then we will obviously go to questions from the audience and maybe even have an internal discussion. Now, without further ado, I give you, Ambassador Sharp, the floor is yours. Thank you very much.
Thank you very much, and welcome to everybody. I mean, whether or not the constitutional question is the main impediment to a peace agreement, I pass no judgment on that. I think that's an Azerbaijani perspective, but I was just asked to sort of give some background on how we dealt with a constitutional question in the case of the Northern Ireland peace agreement. As you say, called the Belfast Agreement. Now, everyone's referred to it as the Good Friday Agreement, and everyone does refer to it as the Good Friday Agreement because it was signed on the 10th of April, Good Friday, 1998. But the formal title is actually the Belfast Agreement. So excuse me if I call it Belfast. That's just what it is. So what I was going to do is just run through a number of slides quite quickly. I won't dwell on some of them because I don't want to take up too much time. But I want to just give a bit of background, a bit of context to the agreement, and then an overview of the Belfast Agreement, and then look at the constitutional issue, which is really what we're here for, but then also go through some of the other issues that were covered in the Belfast Agreement, because it was much, much, much more than simply a constitutional change by the Irish Republic. So do I have the clicker there? I think. Let me see if it works. So if I go into slide 2, there we go. So historical context, you can see it goes back, I mean, at least as far as Armenia, Azerbaijan and Nagorno-Karabakh, I suspect, back to the 1100s. As you say, 1600s, the conflict takes on a religious tone. And actually, this is also reflected in the colours. If you look at the Irish flag, it's green, white and orange, and green is the colour of Catholics and orange is the colour of Protestants. So you could almost argue that the Irish flag is a territorial claim in itself. But I mean, orange, of course, is also, the orange being Protestant colour is also why the Dutch play in orange football shirts. It's the same reason, and partly because the Protestantism, the colour orange of being Protestants, came to the United Kingdom, came to England from William of Orange, who was the ruler of Holland in 1688. So there we go. So that's the background. In the next bit of historical context, we move into the 20th century. Hopefully. There we go. Sudden jump into the 20th century. So essentially the troubles you saw in the first slide in the 1900s, early 1900s, led to a treaty and the Irish Free State in 1922. And Northern Ireland, as it says here, remained part of the United Kingdom. Now, that peace treaty was actually disputed within the Republic of Ireland, or the Irish Free State as it was in those times, and they had continued fighting amongst different factions within Ireland because of dispute over whether or not they should have signed a peace agreement which allowed Northern Ireland to remain British. And then we jump forward to the 1960s when which is, I suppose, the most relevant in terms of the peace agreement. Civil unrest started, and I mean, ironically, the UK Army was actually sent to Northern Ireland to protect the Catholic minority, and then became the focus of the provisional IRA's efforts to kick the United Kingdom out of Northern Ireland. So the next slide is just going to be a nice little picture, a nice little map. This is kind of what the 6 counties look like. So it's called, you also might have here references to Ulster or the 6 counties, and that means Northern Ireland essentially. And the 6 counties, you've got Antrim, County Down, Armagh, Tyrone, Fermanagh, and it says then Londonderry. So just an example of the differences between the Catholics and the Protestants. No, if someone says Derry, then that's a Catholic. If someone says Londonderry, they're Protestant. So you can automatically tell where, what religion they are and whether they're Unionist or Republican, depending on whether they call it Derry or Londonderry. So little things like that will distinguish the differences. Right, so moving on to the Belfast Agreement. As I said, commonly known as the Good Friday Agreement, structure 2 agreements. So the UK, the actual interstate agreement was very, very short, only 4 articles. The big agreement, the really long one containing all of the detail, was something called the Multi-Party Agreement, and that involved 8 political parties from Northern Ireland and the 2 governments. So very much it was very much a community-led series of negotiations involving both the Catholic political parties and the Protestants, and on the Catholic side, including Sinn Féin, who are seen as the political wing of the IRA. But the Democratic Unionist Party, which was the main Protestant party in Northern Ireland, did not sign this agreement. They were the big standouts. They just thought that the agreement gave too much to the Irish, too much to the Catholics in Northern Ireland, and they refused to sign it. But very much a community-driven process, I think, very important point to make. It wasn't simply a top-down process imposed by the 2 governments. So on to the sequencing. So I think Farid started to refer to this about the way it had to happen, in that the agreement was signed, but then had to be approved by referenda in both Northern Ireland and the Republic. And they were asked sort of different questions, if you like. So I mentioned the structure of it, the 2 agreements. So the Northern Irish voters were asked to support the multi-party agreement, and the Irish voters were asked to approve the constitutional changes in the Republic of Ireland's constitution. So the agreement signed 10th of April, referendum held in both Northern Ireland and the Republic on the 22nd of May, so just a month over. And you'll see that in Northern Ireland, in Northern Ireland, 71% in favour. So a high turnout in the Northern Ireland, 71%, which sounds quite good in favour. However, overwhelmingly in favour amongst the Catholic community, Protestant community, only about 53 or 54% in favour, which again reflects the fact that the DUP didn't support it. Whereas in the Republic, a small turnout, but massively in favour. And then what then happened, sorry, there's one line I haven't put in there. So the Irish Constitution, there was a conditional amendment of the Irish Constitution on the 3rd of June, i.e. a couple of weeks after the referendum. And then that conditional amendment to the Constitution was then confirmed on the 2nd of December 1999, i.e. the point at which, so just after, immediately after the agreement came into force. So there was a clear sequencing, which we'll look at in the next slide. Now, you probably won't be able to read this, but that essentially is setting out the conditionality. That's Article 4 of the UK Republic of Ireland Agreement, So it would be a requirement for entry into force that the amendments to the Constitution of Ireland should have been approved by referendum. And then immediately on to entry into force in this agreement, the Irish government shall ensure that the amendments to the Constitution take effect. So the agreement was signed before the referendum and also before the constitutional change, but the changes to the wording in the Constitution were agreed by the governments and as part of the both agreements. So in the multi-party agreement, reflected in the multi-party agreement and in the UK Republic of Ireland agreement. So just the sequencing of it all just needs to be borne in mind. So the constitutional issue itself was that. So Articles 2 and 3 of the 1937 Constitution made what were regarded as territorial claims on Northern Ireland. And that so accepting the agreement, signing the agreement, the Republic accepted for the first time that Northern Ireland was legally part of the United Kingdom, a very important change in their position there. So when Fareed's taking this photograph, I'm going to move on to the next slide. So that is the original version from 1937. So Article 2, you see, the national territory consists of the whole island of Ireland. And Article 3 is mainly just, it's a jurisdictional question, but it does refer to, pending the reintegration of the national territory and refers to the right of Parliament to exercise jurisdiction over the whole territory. So both of those articles are clear claims on British territory. So those two were changed completely. And this, again, you won't be able to read, but essentially this switched from territorial question to focusing on people. So it then became the entitlement and birthright of every person. And it talked about the Irish nation, about cherishing its special affinity. So Article 3 refers to the firm will of the Irish nation to unite all the people who share the territory of the island of Ireland. So for the DUP, the Democratic Unionist Party in Northern Ireland, that was one of the things they didn't like, and one of the reasons they didn't sign the multi-party agreement was because they saw that also as an implicit claim on Northern Irish, on British territory, on Northern Ireland, by expressing the desire to unite all of the people, which in their view, they don't want to unite with the Republic of Ireland, of course, they want to stay part of the United Kingdom. So they couldn't support that particular line in the new Irish constitution, so they didn't sign the whole agreement. So this slide is the multi-party agreement. So it's how what I've just described was reflected in the second part of that structure, the Belfast Agreement structure, the multi-party agreement. But the key thing to look at here is the bit in red. So we're kind of moving on now. And I said earlier there were a range of different things in this agreement. So I know that Azerbaijan's looking at the constitutional question, the territorial claims, and how to get rid of those from the Armenian constitution. But the Belfast Agreement contained a lot more than that. And you're going to see some of these things which are contained. And you'll probably feel a lot of those are not appropriate to your situation, which is fine, because I think every case we're looking at, that some bits will be appropriate, some bits will not be appropriate. But it's just worth realizing that this was a negotiated document, so there were a series of compromises on all sides. Hence the fact that DUP didn't like some of the British government's compromises, and there'll be some compromises and some things here which you will not think are applicable to your situation. But you just have to be aware that these were in the Belfast Agreement. So the bit that's sidelined in red is important, and I better read it out. Actually, if I can read it, the light's not so good here. So the Government of Ireland Act 1920 is repealed. So that was essentially this. So the United Kingdom had legislation in place dating from 1920, which I promise you, there's probably only about 10 constitutional lawyers in the United Kingdom that were aware of this. No one else was aware. This was just a bit of legislation that was passed in 1920 before we signed the Anglo-Irish Peace Agreement. This was during all the time when the Irish were pushing for independence. There was a rebellion, the Easter Rising in 1916. There was unilateral declaration of independence 1919. So there's a lot of problems going on in the relationship at that time. So the United Kingdom at that time decided, I think it probably saw trouble coming. So at that time it passed legislation to essentially say, okay, this is the whole of Ireland. It all still belongs to the United Kingdom, However, we're just going to sort of territorially divide it up for administrative purposes. So they passed this legislation, which was then overtaken by the Anglo-Irish Treaty of 1921, but it was never repealed. So again, coming back to some of the conversations we had about Azerbaijani legislation, which has been looked at by the Armenian side, and you've been told that needs to be changed as well. This was something that the United Kingdom had to change as part of, well, not change, but just repeal. But it was just outdated legislation. So we're now going to move on to even more contentious aspects of the peace agreement, which you probably won't think are appropriate to you. So this text here is this is Article 1 of the Anglo-Irish Agreement. And the good thing from a British point of view is that it recognises Northern Ireland as part of the United Kingdom. As I was saying, it's the first time ever the Irish government recognised that, and this is one of the places in the text where it recognises that. But equally, it also talks about self-determination. Article 1, subpara 2, talks about the exercise their right of self-determination. And this next one, this is a continuation, different size typeface, but it is actually a continuation of Article 1. That is also, again, recognising the right of self-determination. And the bit sidelined in red is about the right of people living in Northern Ireland to take dual citizenship, to take the citizenship of the United Kingdom or the Republic of Ireland as they see fit. Which in practice happened anyway, quite frankly. I mean, because the Irish government recognised Northern Ireland as part of the Irish Republic, it meant people living in Northern Ireland could always take Irish citizenship. But this actually, from the United Kingdom's government side, it recognises their right to do so. And then you have this is just some of the structure of the multi-party agreement, which was much, much more extensive. As I say, the Anglo-Irish peace treaty was, the Anglo-Irish agreement was only four articles. This one is much, much longer, containing, as you say, different strands, all the provisions for what would happen in Northern Ireland, and then provisions for the relationship between Northern Ireland and the Republic, and then also the relationship between the United Kingdom and the Republic of Ireland. And I said NB, the role of mediator. Again, we did accept mediators. A guy called George Mitchell, a senator who was assigned by Bill Clinton to come and help the parties reach consensus, and it was very, very valuable. He just spent a lot of time in Northern Ireland. I mean, it wasn't an easy process. Talks broke down. They then got restarted later on. They went on for 2 or 3 years or so, but eventually managed to sign that agreement. And that is, again, some of the issues that were addressed in Strand 1 is what will Northern Ireland look like? What things do you need to change? Security, policing and justice, which for the Catholic community, the minority community, was seen as very biased against them. So they had to be completely reformed. I mean, the Royal Ulster Constabulary, for example, was renamed the Police Service of Northern Ireland, simply because the notion of being royal had the British connotation, which wasn't acceptable to the Catholic side. Decommissioning of the paramilitaries. So it wasn't just the provisional IRA. The Protestants, the loyalists, also had their own paramilitaries, which had to be decommissioned. But that decommissioning took several years. I mean, it was signed in 1998, but the decommissioning by the provisional IRA wasn't completed until about 2005. So there's certainly, and that was also with the involvement of another mediator, a Canadian general. So again, it's an example of actually how the process can take much longer than you'd like. And there were a couple of issues in Strand 1, which then had to be renegotiated. So there were some revisions to the Belfast Agreement for Strand 1. So it wasn't signed, sealed, delivered, and never changed again. Prisoner release, still very contentious. Equality and human rights, again, seen as being very pro-Protestant. Those institutions had to be changed. In terms of the cross-border bodies, a lot of them, basically. So some of them were just, they agreed, but they implemented separately. Some were joint implementation, and some were informal cooperation. I mean, there's always, to be honest, if you look at rugby, if you follow rugby, there's long been an all-Irish team in rugby. It's just worked. Northern Ireland, Republic, they just played with Ireland. Football's separate. Northern Ireland and Republic of Ireland have separate football teams. But as I say, it's very, there were some cross-border links operating even before this peace agreement, but now they've been institutionalized. And then just some other issues which weren't in the agreement, but they do have a bearing on the relationship between Northern Ireland and the Republic and the United Kingdom and the Republic. Common travel area, for those that you don't know, I was going to say we have a mini Schengen, but it's not quite a mini Schengen, because if you go to the United Kingdom, you still have to get a visa to go to the Republic of Ireland unless you come from certain countries. But for the British and Irish people, it's essentially a common travel area. It's the Irish people, there are no restrictions, come into the United Kingdom to live, work, study, do what they like. Very, very large Irish community in the United Kingdom. And that's just been long been like that. They're able to vote, irrespective of whether we're in the European Union or not. So the EU relationship is not relevant to a lot of the rights of the Irish people to come and live and work in the United Kingdom. And the implications of Brexit. Northern Ireland is, I don't know how much of you followed, how many of you followed the ins and outs of the Brexit process, but Northern Ireland brought down the British government, the Theresa May government. What to do about Northern Ireland as a result of Brexit was a complete nightmare for British politicians, because and the relationship between Brexit and the Good Friday Agreement and the common travel area, because we've said no border, there's no border controls between the United Kingdom and the Republic of Ireland. If you get on a bus in Belfast, you just get off in Dublin and that's it. No checks whatsoever. But that was all agreed. There should be no border. So all of the border posts, the military border posts had been there until 1998, were all removed. And it was just a borderless island. But of course, how you reconcile that with Ireland being in the EU and the United Kingdom not being in the EU in terms of customs and single market and all of those issues was an incredibly difficult issue. As I say, Theresa May negotiating the agreement, it was rejected by Parliament. She resigned. Boris Johnson came to power, negotiated a new agreement, and that sailed through. Everyone cheered, and then Northern Ireland realised actually they'd been royally screwed by the Prime Minister. And it then came up again, the agenda, and just last year? Maybe the Windsor Framework, which Rishi Sunak, the former Prime Minister, negotiated with the EU to revise some aspects, or to, I suppose, to clarify some aspects of the Brexit withdrawal agreement and how it applied to Northern Ireland in terms of customs controls and things like this. So essentially what we did was we put a border, instead of the border between the United Kingdom and the Republic of Ireland, we installed a border between the United Kingdom and the United Kingdom in the North Sea between the mainland and Northern Ireland. Very complicated and very lot of hostility from the unionist side still. Anyhow, so as I say, kind of it's the gift that keeps giving, quite frankly, Northern Ireland. And yeah, when it comes down to it, if you had a referendum in the United Kingdom asking, do you want Northern Ireland to remain part of the United Kingdom, you may well find a majority in favour of it being reunified. And the whole question of reunification is a live issue. It has been a live issue in the recent Irish elections, where Sinn Féin, who are now the largest party, the Catholic Party, the largest Northern Irish political party, now have First Minister for the first time in Northern Ireland, also campaigning in the Republic of Ireland. If they won, they would then hold a referendum, push for a referendum on the future of Northern Ireland and unification with the Republic. They didn't win, and I think that the previous two coalition partners are probably going to form a new government. But I think it just shows that this issue remains very, very live, and also that constitutional change. Well, it was important to us and important to the Northern Irish Protestant community. Nevertheless, it was only one part of a very multi-layered and complex agreement. So thank you very much.
Thank you very much. Can we have some lights? Wait, do you have a presentation?
No, I don't.
Mita? No, good. Okay, so let's turn on the lights, and I would like to give the floor to Mitat Çelikpala, who's also going to come up and speak from the podium. Lights, please. Someone, so that we're not in darkness.
Yeah, thank you. Thank you very much, Mr. Chairman. It's always a kind of pleasure to be in Baku. After a long while, I had a chance to be with you again in front of you, and it's a kind of privilege and honor to take part in this event, or the two sessions on the processes of peace between Azerbaijan and Armenia. And in the first panel, Ferit Şafiye mentioned that there are many distortions regarding the processes to understand what's going on between Azerbaijan and Armenia, and is it possible to have a kind of a peace agreement, a final and sustainable peace between two actors, because, you know, it is very closely related with Turkey or Turkey-Armenia relations, and as well as it affects daily life of Turks, of Turkey, and of course Azerbaijanis in Azerbaijan. And, you know, most of the time we say that we are one nation, two states, and Azerbaijanis follow very closely what's happening in Turkey in a domestic and international relations areas. It was the case for Turkey as well. And despite this closeness and observing each other very, I don't know, effectively, there are many distortions in Turkey as well. Therefore, this session is very important to clarify and shed light to discussions and the processes. And I'm observing everything very closely regarding the Caucasus, and especially between two actors and Turkey's foreign policy towards those regions. But, you know, I have many questions, and most of them were clarified during the first session. And this is a kind of an example, in fact. And Turkey experienced a kind of a rapprochement or normalization processes with Armenia, you remember, in 2010. And this process was halted mainly because of the Constitutional Court's decision regarding the application of or the approval of the protocols. Therefore, it might be a kind of an example. And I clearly understand why Azerbaijan is insisted on such a kind of a change of Armenian constitution, or making null or void, Elchin mentioned in his presentation, of the declaration of independence of Armenia somehow or some way. And to say the last word from the beginning, it might be a chance for Armenia to reach out a kind of a final peace and, of course, resolution of many issues, not only with Azerbaijan, but with Turkey as well, which is an important, I don't know, pillar of sustainable peace, and to create a kind of a new Caucasus for all the regional actors. From this perspective, what is the case? You know, it was mentioned, Armenian Declaration of Independence, August 1990, and it contains territorial claims, not only against Azerbaijan, but against Turkey as well. And, you know, despite this declaration, let me go through it. And the Article 11 of the statement says, Turkish territories referred as Western Armenia, and allegations against Turkey are expressed as follows. The Republic of Armenia stands in support of the task of achieving international recognition of the genocide in the Ottoman Turkey and Western Armenia. And this phrase, Western Armenia, refers to the eastern provinces of Turkey, Eastern Anatolia, and partly southern eastern part of Turkey. We have 7 regions in Turkey, and this Western Armenia in code means almost all the eastern and southern parts of Turkey. And it was in 1990. And despite this declaration of independence, Armenia declared its independence in September 1991, and Turkey recognized this independence in December 1991. Of course, there was no diplomatic relations between two parties, and because of Nagorno-Karabakh, we closed the borders with Armenia. But, you know, Turkey tried to take a kind of a step to normalize or to establish better relations with Armenia. And then comes the Constitution of 1995, and its preamble, it was discussed in the previous session in detailed way, basic foundations of Armenian statehood and pan-national aspirations embodied in Armenians' Declaration of Independence. They reiterated the same case. Of course, you may say that you cannot compare Turkey or Turkey and Armenia as actors, or I don't know, the sizes are too different, and it is not the case for Turkey. Do not take it very seriously. But, you know, after almost 35 years, and we have an experience in MID, and this is still on the table, and we have to discuss the issue from this perspective. And in sum, the Declaration of Independence and, of course, the Constitution itself constitutes they are all, both of those documents endorse territorial claims against Turkey. And the second thing, you may find many articles on this issue, Mount Are, and they call it Ararat, it is okay. And they say that it is the Armenian state of flag. And during the negotiations or rapprochement period, this was also an issue, and it symbolizes the reunification with Western Armenia. You know, this is very common. You may say that this is a very nationalistic, or I don't know, some ultra groups defining and positioning themselves against Turkey and try to show the other ways. We have some common understanding between the other. Therefore, it's not that serious. But, you know, at the end, that's serious. And when we tried it, it was the Constitutional Court decision to authorize the protocols in 2010. Turkey experienced it. Both of the parliaments, Turkish and Armenian parliaments, approved those, I don't know, documents, despite the opposition within Turkey, and of course, very harsh criticisms in our Azerbaijani colleagues against those protocols because of its nature and the structure. You know, it was the case. And one of the issues that sparked the controversy in Armenian debates about the protocols texts, not only in Turkey, but in Armenia as well, was the confirmation of the mutual recognition of the existing border between two countries as defined by the relevant treaties of international law. You know, they say that you cannot sign such a kind of a protocol because, you know, it says internationally recognized borders between two countries. It is unacceptable. And there was no mentioning, by the way, from the Turkish side. Turkish foreign minister didn't make it an issue. There was no mentioning of two important agreements between Turkey and the Soviet Union, 1921 Kars and Moscow treaties. And this is very important. Those two treaties define the current border and which commonly create a kind of a irritation among Armenians. And both governments of the days, let me say, try to balance it, but particularly among the hardliner Armenians, nationalist groups and diaspora groups started to negotiate or discuss those protocols from this perspective, and especially Dashnaks, they were very harsh on this discussion, and they said that it's impossible to recognize such a kind of a development. And they mentioned the agreement of Sevr, and Sevr is a kind of a, I don't know, unacceptable discussion in Turkey. No way, because, you know, it's an old agreement, and Turkey removed this Sevr agreement from the scene through War of Independence. This was the case for Azerbaijan now. Therefore, from this perspective, even the protocols negotiated for 2 years between the politicians of the era, and despite the fact that the ratification of agreement between two parliaments, and then we have very critical positioning of diaspora, oppositional Armenians, and the others. And, you know, there is a text, an Armenian Revolutionary Federation. The current borders with Turkey are not legal. Historically, Western Armenia, referring to the Eastern Anatolia, as I said, is ours. Armenia and Turkey have never agreed on the current borders. If Turkey continues using Western Armenia as it does now, it will have to pay for its use since 1915. And then comes diaspora and reparations. You know, those are the complicated issues. Of course, it is true to separate modern-day Turkey-Armenia relations from Turkish-Armenian relations as a political move, and to move forward and to serve the peaceful environment within the Caucasus, as well as all those environments. But, you know, this is a political stance. And it seems impossible to reach out a point, and Turkish authorities saw that it's not easy even to struggle within Turkey's domestic issues and sign such a kind of an agreement or protocols with Armenia, despite many criticisms. It is possible to create a normal environment, but it shows that it is impossible. And Constitutional Court, what happened? Let me check my notes. They say that, of course, these protocols are okay at a level, but you cannot remove Declaration of Independence and the limitations of the Armenian constitutions through those protocols, which is the question mark in the first session. If the parties sign an agreement in the coming future, a new government or the Constitutional Court take a decision, and after a while that those agreements are not effective and efficient. And then you are going to go back to the square one. And this is the issue, and we experienced it. And what happened? Let me read a piece as well and finalize my presentation then. Sorry. Yeah, I have notes on my phone, some limited positioning. Where is it? Yeah, here. On January 2010, afterwards, after the Armenian Constitutional Court's decision, and it says the Republic of Armenia on the case on determining the issue of conformity with the Constitution of the Republic of Armenia of the obligations stipulated by the protocols between Armenia and Turkey signed in Zurich, and they say this is not the case. You should respect the Declaration of Independence and Constitution. And then a while afterwards, and in 18th of January, Turkish Ministry of Foreign Affairs stated that the Armenian Constitutional Court decision contains preconditions and restrictive provisions which impair the letter and the spirit of the protocols, which means Armenian Constitutional Court politicized the issue, and there is a potential to politicize any kind of an agreement between the governments, and it's a danger for the further developments. In sum, if such a kind of a rewriting or having a new constitution, most probably up to the Armenians, of course, but such a kind of a development has a potential to normalize relations with Turkey as well. Without having such a kind of a move, it seems that the protocol experience showed that it is impossible to normalize. And it makes everything connected with Azerbaijani, Armenian, sustainable and final peace processes. And then most probably Turkish authorities are following the issue from very, closely from the beginning. Hopefully they do it, and we will have a kind of a sustainable peace with not only between Azerbaijan and Armenia, but between Turkey and Armenia as well. Thank you very much for your interest.
Thank you very much. Two sort of big picture takeaways from these first two presentations, it seems to me, is the first that Jamie made was one of sequencing, which is politically, not just constitutionally, but politically very important in the context of the execution of whatever ends up being agreed. And then the second is velocity, right? Mithat brought this up, the fact that in the execution phase, too much time passed before each of the sequencing steps, and how that played at least some role in the failure, which, as it happens, maybe wasn't such a bad thing, given that it helped repair the relationship between Turkey and Azerbaijan, but still. Okay, third and final speaker, Zhidas Daskalovsky, professor of political science from North Macedonia. Please, you will speak from there. Wonderful.
Sure.
The floor is yours.
Thank you. First, I would like to thank Farid for inviting me here. It's a pleasure to be in Azerbaijan and Baku and participating in this roundtable. Second, I would like to say that beyond being professor of political science at the University of Kliment of Ohridsky and director of the School of Public Policy Mother Teresa, I am also foreign policy advisor to the Macedonian president. And whatever I say or not say today here, I'm doing it in my personal capacity. I do not represent the cabinet or the office of the president of Macedonia. Thirdly, I would like to thank Deputy Foreign Minister of Azerbaijan, Mr. Mamadov. He's not here, but I would like to thank him for pointing out the fact that the deals between Macedonia and Greece and Macedonia and Bulgaria, and especially the first one, have potentially repercussions and have some kind of could have some kind of influence on the deal Armenia and Azerbaijan can make in the future. Now, what I will do, I will have one minute historical overview. Then I will speak 2 minutes, maybe presentation of the positions of the governments in Skopje and Athens and Skopje and Sofia. And then I will speak about 10 minutes on the actual deals and legal changes that happened following the deals between Macedonia and Greece and Macedonia and Bulgaria. Now, in principle, the history of the region or the country of Macedonia is fairly simple. It had a glorious past in the ancient Macedon, the kingdom famously known for the rulers Philip II and Alexander the Great. It disintegrated with the death of Alexander the Great, split in 3 parts, and then was defeated by the Romans in the 4 wars between the Macedonian Empire and the Roman Empire. Since then, it was, this is before Christ 148, the last war. Since then, it was ruled by the Roman Empire. In certain period of history, this eastern part of the Roman Empire was the only part of the Roman Empire existing. It was called the Byzantium. It was ruled until the 14th century by the Romans, but there were periods in the 10th and 11th century where the medieval kingdoms of Serbia and Bulgaria ruled the area of Macedonia. Now, the Byzantines were defeated by the Ottomans. The Ottomans finally defeated the Byzantine Empire in 1453, and from this period, 14th, 15th century, Macedonia is part of the Ottoman Empire. In the 19th century, all these small states in the Balkans appeared, first Greece, then Serbia, followed by Montenegro and Bulgaria. Macedonia did not get any kind of independence at that time. On the contrary, the neighboring countries, Serbia, Bulgaria, and Greece, had territorial ambitions to basically seek the Macedonian lands, and they did so in the Balkan Wars. So in 1912, 1913, and followed by the First World War, Macedonia as a region was split between Greece, Bulgaria, and Serbia. The part which is today Republic of Macedonia is the part that was ruled by the Serbian Republic and then Serbian Kingdom, which joined the other nations in the Kingdom of Yugoslavia. In 1941, there was a partisan movement in the Macedonian part of Yugoslavia, and subsequently this part declared independence in 1944, but joined the Yugoslav Federation led by Josip Broz Tito, the communist leader of Yugoslavia from 1944 basically to 1980. As this new Yugoslavia disintegrated in 1991, the part of the Socialist Republic of Macedonia declared independence, but had problems in being recognized in the world due to Greek objections. Greece objected to the very name of the country and to the possible legacy of Macedonia concerning the ancient kingdom of Macedon. This was a problem which resulted in the admittance of Republic of Macedonia to the United Nations as the temporarily being referred to as the former Yugoslav Republic of Macedonia. Now, the talks within the United Nations lasted for decades, not being very successfully resolved. What happened as a resolution to this dispute was influenced by the ambitions of the Macedonian government to enter the EU and NATO. It is candidate to become member of EU since 2005. It was candidate to become member of NATO for a long period since 2005. It was not admitted at the Bucharest summit in 2008, although Albania and Croatia were admitted at that time. And all the governments within this period so basically since independence until 2016, sought a good deal with Greece, which they did not get. The government that led the country, the Social Democrat government that led the country since 2016, made the steps to solve the issue with Greece, and they negotiated directly with Athens for 2 years, finally making a deal in 2018. This is the deal called Prespa agreement because it was signed near a town near the lake of Prespa, bordering both countries. The deal stipulated that basically the country would change the name from Macedonia to North, that the historical part, the historical legacy of the Greek Macedonian territory will be interpreted by Greece on their own, that there will be constitutional changes, and that Greece will lift the de facto veto on Macedonian entrance to NATO. The constitutional changes were required for this agreement to be legitimized. For the constitutional changes to happen, the government decided to call a referendum. The referendum was unsuccessful. Although there was a huge support by USA and European big powers, including Germany, France, and so on, the referendum was very unsuccessful. The turnout needed for the referendum to be successful was 50% plus one, and majority of those 50% plus one to vote in favor of the question asked at the referendum. Unfortunately for that government, there was very low support among the citizens, and although there was a support in the so-called international community, and although there were political manipulations, ballot stuffing, and so on, the total number of voters that turned out was 37%, out of which 34% voted in favor of the idea to legitimize the Prespa agreement. Basically, the opposition parties boycotted the referendum and asked citizens not to turn out. The easiest way to object to the referendum being implemented. Following the unsuccessful referendum, the ruling governing coalition tried to pass the Prespa agreement in the parliament. They lacked 2/3 majorities. They lacked 8 deputies. What happened then was 8 deputies of the opposition parties were basically forced in different manner, or they were lured by lucrative deals in the future made to their families to vote for the agreement. The agreement was finally passed with these 8 MPs from the opposition deflecting and voting for the agreement in the constitution. Now, this is the story about the name change. What you don't know, but it's important for you as Azerbaijani in relations to the Armenian constitution, is that within this Prespa agreement, there is a clause which also stipulates that the Macedonian Republic changes the preamble of the constitution. This is, I think, important for you. What was the Greek objection to the preamble, which was changed within the constitutional changes in 2018-19? They objected to the clause in the preamble which was made, which referenced the 1991 independence to the decisions of the Socialist Republic in 1944 and a manifesto which called the unification, or called the Macedonians in the other parts of the region of Macedonia, so the part in Bulgaria and part in Greece, to fight and liberate their own countries and unite with the Socialist Republic of Macedonia. So this implied actually, and this is already in the past, territorial irredentism on the part of the modern Macedonian state, to the part that Greece controls and to the part that Bulgaria controls. So there was a demand that the changes in 2018 also changed the preamble referring to this manifesto. And this is what happened. Now, very briefly about the Macedonian-Bulgarian relations. Now, Macedonian-Bulgarian relations very modern relations revolve around the treaty on friendship made with the same socialist democrat government that made the Prespa agreement and the deal with the Greeks. There is agreement on friendship, and there is agreement under the auspices of the European Union that Bulgaria will not stop the European integration of Macedonia if, among other things, it recognizes the Bulgarian minority in the Republic of Macedonia within the constitution. Now, the opposition at the time and the current government was objecting to this demand, not only because it's another demand to change the constitution, but also because Bulgaria asked for historical changes and historical interpretation of the history, which is in the liking of the Bulgarian point of view of the history. The proposal of the Macedonian government, the current government, so this is the Demo-Christian government in power now, is that the constitutional changes happen only after the country is admitted to the EU. So it's sort of, there is a sort of clause, they ask, there is a clause put, okay, we will admit the Bulgarians in the constitution, but the article, the amendment will be valid only when Macedonia becomes member of the EU. Now, these are the talks currently undergoing on. I don't know what will happen. It's possible that this will be some kind of compromise. Overall, I'm now concluding. Let me explain that what was necessary in the Macedonian case for the changes to happen in the relations with Greece is that there is a political will. As I said, from 91 independence to 2016, there was a will to make a deal, but will that asked for some kind of fair reflection of the interests of the Macedonians. In 2016, there was a government which basically said that we will do almost everything possible to find an agreement. So there was a political will on the governmental coalition at that time. There was international support, and there are international guarantees in place regarding this so-called Prespa agreement, mainly from the United States, but also from the European Union. What are the dangers? And I think this was also part of the discussions in the first panel. The dangers are that the society does not actually accept these constitutional and political changes. As I said, the referendum was overwhelmingly not supported. Basically, there was an objection to the deal, and there is still objections to the deal to the effect that almost nobody in the public discourse in Macedonia uses the N-word. This North is being used only by Macedonian politicians, diplomats, and state officials in international fora and international conferences. They don't even use it in political discussions within the country. Even the social democrats who are now in opposition they do not use the N-word inside the country. So overwhelmingly, there is opposition and non-acceptance to the change of name, and I don't know how long this kind of situation can last. This I'm saying in relations to the possibilities that the Armenian government pushes for changes which are not accepted by the Armenian society as a whole. And finally, the final sentence: the idea that you could sign an agreement where one side obliges to make changes of the constitution in the future is a possibility for maybe signing a peace agreement when Azerbaijan and Armenia agree on a peace agreement, but there is some kind of time frame where Armenia will be changing the constitution. I think you would probably need very strong international guarantees from different great powers in the world to do this. Thank you.
Thank you, Židas from Macedonia. Let's see if we have time for a question or two. Is there anybody here from the audience? I don't know if Onik Krikorian is still with us. Perhaps he has a question if this is technically possible. Does anybody else, before we further explore this possibility? Questions, comments, snide remarks? Farid.
Yeah, just I want to comment a few things. Again, thank you very much for all these excellent presentations. I would like to address one issue that somehow, again, Azerbaijan is holding back Turkish-Armenian normalization. You, Mithat Bey, said what Armenia and Turkey had and tried to overcome. But I would like to mention 3 episodes. First episode, that when Armenia became independent, Turkey extended hand, even offered during the very harsh winter of '92 to deliver bread and some other food items to Armenia. And but definitely there was issue of reconciliation, but also it was Turkish expectation that Armenia will cease any territorial claims towards not only Turkey but also to Azerbaijan and the conflict. Unfortunately, and there is very good, by the way, if people didn't read the memoir of Libaridian, former foreign policy advisor to Armenian president. He said that it was indeed the desire of the Ter-Petrosyan and ours. And when some of the European ambassadors came to Libaridian and came to Ter-Petrosyan and said, oh, you are going to renounce all claims towards Turkey. So that episode shows that this moment was also kind of interference from the Western side, but also that Turkey was really making good gestures. And second episode, 2012, 13, when the President Sarkisyan said to the youth Armenians that we resolved the issue of Karabakh. That means we united Karabakh, and the future generation should resolve the issue of the Western Armenia. So it's not something invented right now. It was there along the line, 90s and 2000s. And the last episode, before the war, Armenian president at that time said that we have to revise the Treaty of Sevres. And as you know, Treaty of Sevres was the imposition of the Western powers on basically splitting Ottoman, not only Ottoman Empire, but even what is today Turkish Republic in several pieces. And it was never ratified, was never came into force. As you know, we have laws on treaties, etc. So that was before the war, and the same Libaridian, he published article in Armenian newspaper in diaspora, I think Armenian Mirror, said, do you realize that you just made officially claim towards Turkey? So all those episodes, it's not accidental. This is the line which was present in Turkish, in Armenian narrative. So it's not only about peace between Armenia and Azerbaijan. It's about the indeed long-term solution for all 3 countries. So that's why it's not like Azerbaijan is holding peace and normalization. It is a real issue which might resurface. And I'm just the last note referring to what our distinguished colleague from Macedonia said, Zydis, that the guarantors, we had, I mean, international community just recently marked 30th anniversary of Budapest Memorandum, which is now a piece of paper, as we know. So international guarantors, I don't think it is a workable solution, but it's indeed the countries involved, first of all, Armenia and Azerbaijan, should really create the condition for durable peace between Armenia and Azerbaijan. Yeah.
Thank you very much, Dr. Shafiev. Thank you very much, Dr. Shafiev. I would like to give the floor.
Thank you.
Go ahead.
Thank you. I'm very grateful to all the panelists. Really very thought-stimulating presentations. Thank you all. I have a comment, maybe follow up to what Farid has just said. It regards the international guarantees, mediators, or big players. In Europe, you had their own complicating factors, of course. But there's a European Union based on common values, common interests, and even geopolitical interests coincided more or less. And all the key players had their, I wouldn't say identical, but mostly common vision towards the future of some conflicting areas like Balkans, for example. Here, it is so complicated because immediate neighbors to our region, Turkey, Russia, and Iran, none of them has good relations with all three South Caucasus countries. For example, Turkey has good relations with Georgia and Azerbaijan, let's say bad relations with Armenia. And I say good, bad as a relational term without filling in them with a particular content. Iran has good relations with Georgia and Armenia and bad relations with Azerbaijan. Russia had, until recently at least, good relations with Armenia and Azerbaijan, bad relations with Georgia. So that, to a certain extent, gave us all, the small South Caucasus countries, a room for having more or less freedom of choice in terms of foreign policies. Because when the interest of all three big players, Russia, Georgia, Turkey, and Iran, coincide, it's a nightmare for us because you can do nothing then. So for us, it is good when they have conflicting interests because we can play upon them. But that's not good for the peaceful resolution of conflicts. Plus, the regional behavior of these South Caucasus countries are also different. Georgia, at some point, they even went as far as regarding themselves not a Caucasian country, but a Black Sea country, which they always failed to explain. Armenia has always been, and still to the greatest extent, an ally of Russia, given the participation of Armenia in all Russian-centered treaty formats. Azerbaijan, after the Russian invasion to Georgia, stooped back and started pursuing a more or less neutral foreign policies. Plus, ironically, or perhaps paradoxically, in international law, diplomatic relations, because when two countries don't have diplomatic relations, they can choose a protector state. Do you know who was a protector state between Armenia and Azerbaijan? Iran. Because Armenia never trusted Turkey, we never trusted Russia, and Iran was kind of okay. They both agreed, and Iran offered a platform for negotiations in 1992, May 8, and exactly that day, Armenia occupied Shusha. So since then, Iran also couldn't play any mediating role.
Would anybody like to respond of the panelists quickly to any of the comments or non-questions that we had?
No, just the point. Of course, we have many episodes, but for the future, we need to, of course, remember the historical facts and realities, but we need to look at the future to have much more, peaceful, sustainable, and a life in a welfare and prosperous. And therefore, it's very important. And I think we are at a good point, especially from the first session. Therefore, I am an optimistic person from this perspective to see Azerbaijan, Turkey, and of course, Armenia in a peaceful environment.
Thank you very much. Jidas, Jamie?
You want? Okay,
Let's
I
see
think
who can take the least amount of time.
Okay, 1 minute. I think your point is very, very good, sir. It's question whether the region has some kind of balance of great powers' interest and influence or not. You see in the Western or in the Balkans as a whole, USA and EU dominate. In all the countries except in Serbia and the Republic of Srpska, which is the Serbian part of Bosnia and Herzegovina. That means that, for example, any kind of deal between Serbia and Kosovo is more complicated to make because Serbia balances its own role with Beijing and Moscow and Brussels. Any kind of deal between Serbia and Kosovo is more complicated to make than between, let's say, Macedonia and Greece or Macedonia and Bulgaria, who are all more strongly under the US and Brussels influence than Belgrade is. So I think your point is very valid.
Thank you. Jamie?
I don't think we're trying to draw a direct parallel between the situation in Ireland and Azerbaijan and Armenia. It's more about whether or not there are elements of how we solve the problem which may be applicable to Azerbaijan, Armenia. I think that's really what we're trying to do here. I mean, the complexity of it is exemplified by the fact who is Azerbaijan in the sort of the Britain Ireland example? Is Azerbaijan United Kingdom wanting constitutional change in the Republic's constitution, or is Azerbaijan Ireland wanting to actually get the occupation of Northern Ireland of its and be able to reunite its own territory? So they're very, very complex, and it depends on what your perspective is. You can actually sort of see Azerbaijan or Armenia as different players in the Irish context. But as I say, we're just looking at what elements might be applicable, sort of pick and choose, if you like, more of a cherry picking approach, as I understand it, anyway.
All right. Well, thank you very much. There are some things that I could say and disagree with, particularly in the context of this Serbia-Pristina business, but I'm a moderator, so I won't. I would like to thank all of the panelists for their remarks, the audience for listening and for engaging. I think that's it, right? We now have Javid Valiev, who's going to say something. No, Farid Shafiev is going to say something first, and we're done. Thank you all very much.
Thank you very much. I would like to thank all panelists and would like to thank my team headed by Javid Valiev, who made all efforts to organize this event. For any documentation and for wrap up, please contact Javid. He has some conclusion written. And also, if any panelist would like, I know from the first, we will have some written documents also through Javid. You can obtain them. Again, the goal was to discuss what's the obstacle. The question was how it's relevant sometimes experience. We are not claiming that this is any parallels between our case or let's say case in Irish or the Macedonian. We just saying that there is the precedence when the things was resolved through referendum or referenda. So that's the point which we're trying to make in this, at least the second panel. Definitely history of what happened in British-Irish relations in the Balkans and here in the South Caucasus, quite different. But in terms of I mean, here we have the legal experts, international legal framework. Law is law, and doesn't have ethnic application. And if there's some problem, the law should be changed. That was the point, and I would like to thank all who participated and made input. Thank you. Thank you very much.